The legal philosopher H.L.A. Hart defined law as a set of rules for society, but these rules are rarely static. Law is a dynamic tool of governance, engineered and expanding to meet the exact requirements of the society it governs. This diagram represents the keystone of modern Indian governance, the Constitution of India, adopted in 1950. At first glance, it appears to be a single code for a newly independent republic. Tilting this perspective reveals the Constitution as the terminal layer of a deeper accumulation. The modern Indian legal system rests on a four-tier geological stack. To understand how this works, we must map the modern surface layer, the statutes, judicial precedents, and ordinances that govern daily operations. Then we can reverse engineer the historical layers buried beneath it. Understanding this structure reveals why centuries-old texts and colonial decrees continue to dictate modern Indian business, trade, and criminal justice. Looking closely at this top-down node graph, the current system operates through a strict hierarchy of sources, branching downward directly from the Constitution into four main pillars. The first source is statutory law. These are the written laws enacted by the Parliament at the national level and by state legislatures at the regional level. To prevent jurisdictional overlap, the seventh schedule of the Constitution divides this legislative power. It separates the authority to make laws into three parallel tracks: the Union List, the State List, and the Concurrent List. The second major source is judicial precedent. The Supreme Court and the various high courts do not draft legislation. Instead, their formal interpretations of those statutes become binding law. Article 141 formalizes this hierarchy. It dictates that any law declared by the Supreme Court becomes instantly binding on all subordinate courts across the entire territory of India. Legislatures build the mechanical engine of governance through statutes. The courts, through their precedents, write the binding operational manual for how that engine actually runs. The third pillar consists of delegated legislation and ordinances. These handle exigencies when the standard legislative bodies are in recess. Under Articles 123 and 213, the President of India and state governors hold the power to promulgate ordinances. These are temporary decrees that carry the full enforceable weight of standard legislative acts. This delegation of power also flows downward. Article 243 empowers local rural administrations, the Panchayati Raj, to frame highly specific regulations for localized governance. The fourth major source is personal law. The Indian legal system integrates individual faith and customary practices into formalized statutes, producing acts like the Hindu Marriage Act of 1955. The 1950 constitutional architecture intentionally leaves structural gaps. This allows for rapid executive action in an emergency and maintains cultural continuity in personal affairs. But this surface layer rests on a historical paradox. If the Constitution was enacted in 1950, why rely on laws written in the 1870s? We find the answer in the first subterranean layer. This is the British administrative period, spanning roughly from 1600 to 1949. The East India Company arrived as an entity focused on revenue, but as it acquired territory, it evolved into an administrative power that required formal mechanisms for dispute resolution. The Indian High Courts Act of 1861 marked a major institutional shift. It replaced fragmented, localized courts with a standardized high court system in the presidencies of Calcutta, Madras, and Bombay. The British administration replaced fluid ideas of justice with strict written codified law. They engineered foundational texts that remain active, including the Indian Penal Code in 1860 and the Indian Evidence Act in 1872. The Indian Contract Act of 1872 became the bedrock of modern business. It was so comprehensive that over time it splintered into separate standalone legislation, like the Sale of Goods Act in 1930 and the Indian Partnership Act in 1932. By replacing localized decrees with standardized codes, this British layer built the structural framework that modern Indian commerce still relies on. Digging deeper, we hit the medieval period, beginning around the 12th century. The Delhi Sultanate, and later the Mughal Empire, introduced highly centralized administrative justice. During this era, courts were categorized by subject matter. The Diwan-e-Muslim handled disputes concerning the bureaucracy, while the Qazi-ul-Quzat supervised provincial courts and heard central appeals. Finally, we reach the foundational ancient period. This era was guided by universal texts like the Vedas, Upanishads, the Smritis, and later the Arthasastra. Rather than relying on codified statutes, ancient Indian law was based on the principle of dharma, a localized framework that bound legal, religious, and righteous duties into a single guiding philosophy. Ancient Indian courts operated on a rigid six-tier hierarchy. Minor disputes began with family councils, known as the Kula, and escalated up the chain, ultimately reaching the King's Court, or Nripa. While specific laws varied by territory, this era established the underlying logic of an appellate hierarchy, where decisions of a higher court supersede the court below. This ancient framework remains the active logic of the modern courtroom. To bring this historical stack into the present day, colonial ties were severed. This occurred with the abolition of Privy Council Jurisdiction Act in 1949, which stripped the English Privy Council of its authority as India's highest court of appeal. The task of encapsulating this historical weight into a new framework fell to the drafting committee, chaired by Dr. B.R. Ambedkar. The new framework was passed by the Constituent Assembly on November 26, 1949, now celebrated as Law Day, and officially adopted on January 26, 1950. On that day, the Supreme Court of India was established under Article 124(1) of the Constitution, absorbing final legal authority over the Republic. This sovereign infrastructure has expanded to meet the demands of a growing nation, increasing from an original strength of 8 judges in 1950 to 34 today. This brings us back to the terminal layer. The Indian legal system's true genius lies in its synthesis. It successfully fused ancient appellate logic, medieval administration, and British commercial codes into a single cohesive constitutional republic. To govern 1.4 billion people across a vast, culturally varied geography, you need a legal architecture capable of operating at massive scale. The Constitution of India provides that blueprint. It divides lawmaking power across a 2-tier structure, the central government operating nationally and the state governments managing regional affairs. But while it looks federal on paper, it operates differently in practice. Unlike the pure federation of the United States, where states hold immense sovereign power, India operates as a quasi-federal state. In 1994, the Supreme Court of India formalized this definition in the S.R. Bommai v. Union of India judgment. The court observed that the Indian structure possesses a distinct unitary bias. This bias manifests as a strong central machinery. When power is weighed between the 2 tiers, the distribution is deliberately lopsided, heavily favoring the central parliament over the individual state legislatures. If you are navigating Indian business law, recognizing this asymmetrical power balance is the first step to understanding which laws apply to your operations and which governing body has the ultimate authority to enforce them. Every legislative action traces its origin back to this document, the Constitution of India, enacted in 1950. It is the sole fountainhead of lawmaking authority. Under Article 79, the Constitution establishes the Parliament for the Union. This central engine consists of the President and 2 houses, the Council of States, known as the Rajya Sabha, and the House of the People, the Lok Sabha. Mirroring this at the regional level is Article 168. It requires every state to form its own legislature, comprising the governor and the legislative assembly. The structure varies slightly by region. Article 168(2) allows certain states to operate with 2 houses, adding a legislative council alongside the assembly to handle state-specific legislation. Both the central parliament and these state legislatures draw their actual power to draft and implement laws from a single provision, Article 245. Yet, while they share the exact same constitutional origin, their reach is strictly segregated. The bodies are restricted from passing laws outside their specific, constitutionally defined jurisdictions. To prevent the central and state governments from constantly overriding each other, Article 246 acts as a constitutional traffic controller. It assigns specific legal topics to specific lawmaking bodies. This diagram represents the 7th schedule of the Constitution. It divides all potential legal matters into a rigid tripartite matrix: the Union List, the State List, and the Concurrent List. Parliament holds exclusive power over List 1, the Union List. State legislatures cannot draft laws regarding national defense, foreign affairs, or currency. Conversely, the state legislature has exclusive power over List 2, the State List. This reserves issues like local police, public health, and sanitation strictly for regional governments. The final category is List 3, the concurrent list. Here, both Parliament and the state legislatures share the authority to draft laws on matters like criminal law, marriage, and bankruptcy. And through Article 243, this distribution of authority steps down one level further, granting distinct administrative powers to rural governance systems to ensure localized support. Because both bodies can legislate on the concurrent list, it becomes the primary site of constitutional friction. It is here that two different governing bodies frequently attempt to occupy the exact same legal space. This shared jurisdiction creates an immediate logistical problem. What happens when a state law directly contradicts a central law on a concurrent list subject? The Constitution resolves this through Article 254, which establishes the doctrine of repugnancy, the legal term for direct inconsistency between two statutes. Under Article 254(1, the unitary bias of the Constitution activates. If a collision occurs, parliamentary law prevails. The contradictory state law becomes void. This central dominance is absolute. Parliament's law overrides the state's legislation, regardless of whether the national law was passed before or after the state law. However, Article 254(2 carves out a single critical exception that allows a state to preserve its own contradictory law.
If the state law is reserved for the consideration of the president and receives his formal assent, the state-level legislation overrides the parliamentary law, but only within the borders of that specific state. The default setting is always central dominance, but this mechanism provides a narrow administrative bridge, allowing regions to maintain specific legal variations when absolutely necessary. Before a concept ever reaches these jurisdictional lists, it has to physically become a law. All legislative proposals begin their life introduced as bills. If a minister introduces the text, it is categorized as a government bill. If introduced by any other member of the legislature, it is a private member's bill. Inside this chamber, Article 107 dictates the procedure. A bill must undergo multiple readings, intense debate, and rigorous committee scrutiny in both the Lok Sabha and the Rajya Sabha. There are structural restrictions here too. Under Article 109, money bills and specific financial legislation can only originate in the Lok Sabha, bypassing introduction in the Council of States. Only after passing both houses is the final document submitted to the president. The bill only becomes an active law once it receives presidential assent. Because every clause is subjected to rounds of debate and cross-examination, the timeline spans weeks or often months. It is a slow, highly deliberate pace designed to prevent flawed legislation. But deliberate pacing is a liability during an active crisis. There are exigencies where circumstances simply do not permit months of parliamentary debate. To address this, Article 13.3a defines an ordinance as a regulatory instrument possessing the full force and effect of a standard law. Under Article 123, if Parliament is in recess and immediate action is required, the President of India has the power to directly promulgate these ordinances. Article 213 grants a parallel authority to the governor of a state, allowing them to bypass the state legislature to enact emergency rules within their specific territorial limits. These are strictly temporary measures. Depending on when the legislative body reconvenes, the tenure of an ordinance varies from 6 weeks to 6 months before it expires. They function as a vital emergency valve for the executive branch, allowing rapid response to crises. Provided the society changes, the legal framework must be modified to keep pace. Article 368 grants Parliament its constituent power. This is the explicit authority to amend the Constitution itself through addition, variation, or total repeal of an existing provision. This introduces an inherent systemic risk. A majority government could theoretically use this power to delete protective laws or introduce laws that overstep democratic boundaries. At the core of the Constitution are fundamental rights, the baseline legal protections required for human survival, individual liberty, and a dignified life. Article 368 creates a high-stakes tension. It pits the absolute legislative will of the Parliament against the unalterable foundational rights of the individual citizen. When legislative powers are transgressed or constitutional boundaries are pushed too far, the Supreme Court of India steps in as the ultimate arbiter.
The definitive boundary on parliamentary power was drawn by the court in the landmark case Keshavananda Bharati v. State of Kerala. In that ruling, the court established the basic structure doctrine. It declared that any constitutional amendment attempting to contravene fundamental rights or alter the core identity of the Constitution is inherently unconstitutional. If a business or citizen believes a law or bylaw violates this structure, they approach the court. The judiciary evaluates the merit of the situation and dictates the exact validity of the statute. This judicial review operates as the final, non-negotiable check against absolute power within India's quasi-federal machinery. Ultimately, the Indian legislative process is a highly engineered matrix. It grants immense authority to a central parliament, carefully limits regional powers through strict jurisdictional lists, and relies on an independent judiciary to ensure the system never collapses under its own weight.